Not gonna find anything like that in Vermont statute. There's really nothing in Vermont statute that addresses the liability of the dam owner for a failure. You can look at the unsafe dam statute, and we say 1095, it's just not there. You can go to the unsafe dam revolving loan fund. And we say 1106, there is a section or subsection in that section that says, if you received a fund or a grant from the unsafe dam revolving loan fund, A&R may bring an action against you to recoup or reimburse the fund for all loans made from it, but that's not about dam owner liability for failure. The dam safety rule comes kind of close. 37-106 says the dam owner is responsible for the safe management and operation of their dam in compliance with the statutory requirements for dam. And then it goes on to say the owner is solely responsible for significant financial undertaking required of the dam. Well, does that mean liability? But probably not, because when you read further, it says this includes costs associated operation, maintenance, inspection, registration, compliance with standards, engineering, etc. Doesn't reference liability for failure. There is common law.
But question, so if failure, would failure be also sort of a failure of a stated obligation to operate it responsibly? So you make yourself liable for, I don't know, damages or something.
Honestly, that's actually a pretty good question, because what is the standard that you're going to, what is the term? So I think 213 uses breach, but breach doesn't necessarily cover all failures of the dam. And
Is breach generally taken to mean partial failure? I mean, I don't know what legally constitutes a breach versus failure.
I think you could ask the dam safety engineer, which is in the room.
Okay, so great, we'll do that.
There is common law about what the standard is for dam owner liability for when a dam fails. Means 30%. And this was after the 1927 floods, hydroelectric dam failed. I'm just going to read this entire paragraph. It's going to be long, but I love it. The law governing the determination of the issues presented by this exception is well set. For damages suffered are due directly and exclusively to natural causes without human intervention, which could not have been prevented by any amount of foresight, pains, and care reasonably to be expected, there is no liability because it is an act of God. But if the damages are not due exclusively to such natural causes, in other words, the negligence of the one sought to be charged mingles with the operation of the natural causes, the injury is not, in a legal sense, the act of God. So if the injury which the flood occasioned might have been avoided or prevented by human prudence, foresight, pains, and care, reasonably to be expected from the defendant, but not exercised, there is liability. The negligence of the defendant must, however, be an active and cooperating cause of the damage. The mere existence of negligence, not a producing cause of the injury, produces no liability. It must not be merely fanciful or speculative or microscopic, which might not have been in the least degree the cause of the injury. So, if the act of God is so overwhelming, is of its own force to reduce the injury independently of the negligence of the defendant, the latter cannot be held responsible.
What were you just reading from? What year?
That is from the Supreme Court of Perkins versus Vermont Hydroelectric Corporation in 1927. That smells like negligence,
Smells like the flood.
but it's not quite negligence. It's like you're liable for negligence unless the act of God superseded your negligence.
That would have been filed before that would have been filed before the 1927 flood, because that would be November, I can imagine to get a decision.
They probably operated a little quicker than you guys do these days. So let's look at 213. Is 213 strict liability or not? Any lot person who owns legal title to a dam or the owner of the land in which a dam is located shall be held strictly, jointly, and severally liable for harm caused by the breach of the dam, provided the dam has been classified as significant or hazard potential dam by the department. All right, so if your dam breaches and there's harm and it was significant or high hazard, you're liable. That's strict liability. So strict subdivision 1 is strict liability. But there's an or.
Didn't you say it had to be designated before you moved to?
Classified as a significant or hazard high potential dam.
So that hasn't been designated. You know, like,
I believe all of the significant or high hazard dams have been classified. And then there's an or. You are also strictly, jointly, and severally liable if you own legal title to a dam or the owner of land on which the dam is located. You're not in full compliance with any department rules related to dam safety, including rules that set standard for dam design, construction, and maintenance. That, to me, is a factual analysis of whether or not you are exercising your duty to comply with the department rules. That, to me, is negligence.
Yes.
So if you change that and that or to an and, I think you could still say strict liability,
You can change to an and.
but with that or, there's 2 opportunities for you to be held liable, and one of which is your full compliance with department rules and standards, and that's an analysis. That analysis is basically whether you're exercising your duty of care under those rules, and so that seems like negligence.
I had a conversation in the hall with Representative Haley a month ago when he pointed out the or, and he was saying, you should think about turning that into an and. So then, so,
But you are the supreme policy and lawmaking entity of the state, so it is what you want to make of it. When you look around the country, there are various alternatives for how you can make it. You look at Massachusetts, subdivision 1, the owner shall be responsible and liable for damage to the property of others or injury to persons, including but not limited to loss of life resulting from the operation, failure of, or misoperation of the dam. That's strict liability. You're just liable for any of those 3 things.
oh, I'm sorry, where did you jump to?
It's
The Montana code?
it's in Massachusetts,
Okay,
that's strict liability. You're just liable for the damage to property of others or injury to persons from the operation, failure of, misoperation of the dam. That's strict liability.
as opposed to 213, when the first provision of 213 says only if it's significant. So. Okay, I mean,
Then you can look at other examples, Montana. In the absence of negligence, the dam owner is not going to be liable for damages to persons or property, flows of water, for failure of the dam or reservoir. And then Colorado. unless the failure or partial failure has been approximately caused by the negligence of that entity. And then Utah, no one can be held strictly liable. Doesn't say it's negligence, it says that there's no strict liability. And then you can go out there and you can find even stranger standards. Ohio, the dam owner can exempt themselves from inspection by signing a statement that they shall be liable for any and all harm from the failure of the dam.
He's bad.
And so. And then when you're looking at the Google for these issues. And you go to different states and their dam programs. Sometimes wherever you go, it is all the same, and there is guidance that's provided. By an organization called the Association of State Dam Safety Officials, and this document is on many state websites about providing guidance. It includes guidance on dam failure or liability. And it basically says the extent of an owner's liability will vary from state to state, depending on the statutes and case law precedents. The concept of strict liability imposes liability of the dam owner for damages that occur regardless of the cause of the failure. The alternative theory of negligence considers the degree of care by the owner constructing, operating, and maintaining the dam. So I think that is basically subdivision 1, strict liability imposes liability of dam owner for damages that occur regardless of the cause of the failure, just because they have a significant or high hazard dam. Or subdivision 2 considers the degree of care employed by the owner in constructing, operating, and maintaining the dam, whether they're complying with the state dam safety standards. So you asked what is the standard in the state and what is in 213?
Yeah.
I don't know. And so when you go and look at another association of dam safety officials, and their summary of state laws and regulations, it's a really good product, I have to say. It's 240 pages long or something like that, so I didn't want to print it out and put it on your website, so I put the link there for you. It does a great job of summarizing many of the issues with dam ownership and dam safety, and if you're interested in, recommend reading it. But one of the things that
Is it just Montana and Vermont or a different thing?
it's all 50 states, and I think Puerto Rico too. So. One of the things you'll see is that many of the states have this statement in its statute. Like I use California's water code as an example, but many of the states have the statement. Nothing in this part shall be construed to relieve an owner or operator of a dam or reservoir of the legal duties, obligation, or liabilities incident to the ownership or operation of the dam or reservoir. Just because you're permitted, just because you're complying with whatever their code is, their safety requirements, that doesn't alleviate or doesn't relieve you of your liabilities incident to the ownership. So that doesn't say it, but it implies a strict liability. And that's in many states statutes.
So regardless of compliance. That does sort of beg the question, how a dam owner would ever feel comfortable owning a dam, like, unless they found a standard that was.
Unless you're like Utah, and Utah says no strict liability,
Yeah.
you can't be strictly liable. I think Idaho does that too. And, you know, you're just not gonna be held strictly liable, and then it turns into a negligence case, and whether or not you can prove the owner was negligent. And then what comes into play is your compliance with your legal duties, obligations, et cetera, right? And so whether you're conforming with the dam safety rules will be an issue in those cases.
Okay, I think part of how I ended up sort of coming into this issue was from the point of view of clarifying liability. Providing clarity to owners about the risks they incurred by owning a dam. And that liability might sharpen their interest in dam safety so that they would be less apt to face damages or suit.
But I'll go back to what the department's website said and the guidance on the department's website. It's good, right? It's fairly instructive on what your liabilities are going to be, and it even says that generally you're gonna be strictly liable, even though technically I don't think that's correct in Vermont. It's a good forewarning for people that are, gonna buy a dam.
Right. You're right.
Thank you, Chair Bray. Are there any instances of a person who purchases property or becomes the owner of property, inherits it for whatever reason, and there is a dam, they do not have an awareness of the dam being on their property? Where does that fall? Because I could see, is someone if you know there is a dam on your property when you sell it, or when it gets passed to a new owner, are you obligated to inform that future owner of that asset? Because I don't know, I do kind of get where I'm going, in the situation where someone may inherit or get land, then suddenly they're now liable if something goes wrong, having no awareness that they were in fact even the owner operator of a dam.
So, although it's not required, the kind of default realtor disclosure form that realtors give to sellers to fill out, to provide to their buyers, it does have a section in it about, is there anything on your property that there's a flood risk, there's something along those files. But that form is not required to be used by the transactions. And then the Realtor Code of Ethics directs the realtor to know of an issue like a latent failure or liability on the property. They're supposed to notify the buyer of that, but that assumes that the realtor knows of the dam. Sellers are also subject to that in the common law theory, that if they know of a latent issue, they're supposed to, but that would require litigation.
Okay.
Okay.
So if I'm understanding correctly, there is unlikely that someone would not be aware. And if they were to not be aware, that the onus would be on if the previous seller had been aware of it.
I never say never, it's, I expect that there are situations where the property is large enough, the dam is old enough, the owner didn't know, seller didn't know. I'm sure it has happened. But there are protections for that.
That would be my only, in my perspective on this is, and I'm not a lawyer, so this is, I know, you're shocked, I'm not a lawyer. I would like the largest amount of liability to be on the dam owner and the lowest amount of negligence needed for that to be triggered. Like, this is a very serious asset. So what I'm understanding in your description of our legal precedent is that it is a lower threshold to be considered negligent in Vermont than in other places, for example. Your negligence then opens you up to some very serious liability already. And that this change in law would make that even more so. Is that correct? Because I want more liability and it to be easier for you to be found liable. That's how I feel. Is that what this law is doing? If we were doing it,
It's hardly doing it. It's,
oh no,
I'm not really sure what it's doing. It's like, I guess that's my
Yeah,
oh, okay,
takeaway.
for clear white question, says in provision 7.1. If at least for significant or high
Right,
hazard,
then that
like
would
that,
be-
that's clear.
If there was a breach and harm from it, then that person would be strictly liable. But if it wasn't significant or high, and there was a breach and harm from it, then you have to show that they weren't complying with the relevant dam safety standards, which is effectively in, you know, it's a negligence analysis, whether they were applied to check.
The other question for practically speaking is after dam failed. What the ability, what's the ability of some, but that's whether or not there was negligent operation prior to failure. Because, you know, the thing may be missing or already injured.
That'll probably depend on inspection, the last inspection, any dam safety order that was issued, compliance with that order. Et cetera.
And when,
and we had a discussion earlier about who the regulating body of certain dams. Should or is now. When you look at the way we've written the law as it, with the change. There are stricter safety standards under certain regulating bodies. Is my, like DEC, like if we took those 23 dams and made them under DEC versus we had them under the PUC. That would potentially make those utility companies have a lower threshold for what is considered negligence. If, right? Am I?
Yeah, I mean, I understand what you're saying, right, because the safety standards at TEC are more stringent. But I understand what you're saying.
Okay. And I'm actually really okay with that. So, but that is what it is doing, or it could do, if we change the.
If you transfer my jurisdiction, then.
And if we made it and instead of or, it would also make it,
I think if you make it and, there's still some ambiguity there. If you wanna make a strict liability. And that they're just liable for the damages, the harm from a failure, use the Massachusetts language.
not against it.
If that's clearer than this, the kind of common language from, say, California. Where nothing relieves that person of their liabilities, it just says you will be liable. You shall be liable. But it's you, the General Assembly, you're the policymaker, you get to decide. You don't have to comply with the 1927 Supreme Court decision.
no matter how intriguingly and elegantly written. Yeah, well, you know, so to me, provision 1 says there's just a strict liability. 2 says it provides the, if you're in compliance. You're not negligent and you're not liable. That's the correct way to read part 2 alone.
Yeah.
Yeah. So different goals in terms of how we manage things. So I didn't really want to try to solve this now, but
Oh, okay,
it was that I was uncertain about how to read it, and I didn't have any legal context to lay it into. So thank you so much for helping us see the legal landscape.
thought I understood it before, and now I realize I did not, and I also do not now.
Yes.
So I will need to spend time on this.
That's the beauty of law. Going backwards for a while, and then you get through the whole thing. I don't know where, anyway, so we'll have to, I just wanted, and then we'll talk to the agency about how they will get it and manage things, and then we'll think and revise, but that was one.
This may sound like nitpicking, except in, as you know, in the law, exact words have, okay. my understanding is that Vermont style, we do not use the phrase including but not limited to, because the word including means not limited to. Okay, and do we lose anything by cribbing the Massachusetts language except changing that?
No, you do not, because in Title I, we've defined including to mean including but not limited to. And then the Supreme Court has said including means including but not limited to.
So you didn't need me to. It's already been taken care
Thank you, Mr. O'Grady. Wanted to come to the agency. I don't know if the two of you would like to sit together at the table or go in sequence, up to you.
We can go together.
Okay. We're there to support with taking chair and.
I'll bring this. Yeah. Oh, I'm sorry.
Thank you for coming.
Yeah.
To help us get launched into it, I'd say, looking for a response to the new language in 213. And how, I mean, you just heard that discussion, and I don't know what that means from your point of view, as the people managing this, so you have suggestions.
Sure, thank you for having us. And for the record, my name is Hannah Smith. I'm an attorney with the Agency of Natural Resources, and I'm here with Ben Green, who is the manager of the Dam Safety Program. And generally speaking, I from a legal standpoint, I don't, Michael's analysis, we agree with that. There isn't currently a standard of liability that's been dictated in statute or regulation that would determine how a dam failure was assessed by an insurance adjuster or a court, other than the common law, which has generally applied a negligence standard in the past. And so, as Michael said, this policy question about whether the General Assembly thinks the strict liability standard is appropriate is a question for you all. There are some concerns from the agencies. Oh, to take a step back too, this also is really, this language doesn't affect the agency's regulatory authority. So I guess our opinion here may be of less value to you than it is in the rest of the statute. But I think that there are some factors to consider when looking at a strict liability standard and how it may play out on the ground. There was a question about confusion about ownership or somebody not knowing that they owned a dam. And that does happen. Especially with properties where chain of title has been lost or clear ownership of appurtenances are somehow lost when properties transferred. The program is hoping to address that as we actually implement our requirements that all dams be registered, and then those registrations have to be entered into the land records. So in that context, any responsible attorney who is assisting with a land transaction would see that in the land records, hopefully making it very clear that there was a dam on the property. But there are instances where folks don't know that they own a dam. That happens.
And is that part of your current rule or it's in the current rule making?
The requirement that you register your dam is in the current rules. It's in part 1 that was adopted in 2020.
Yeah, I think that's my biggest concern is someone gets this and then we made it very liable for them and then they're in a not great situation.
But as Michael pointed out, that is also the case now because a court would apply a negligence standard and they could still find, if somebody brought a case for damages, court might still find that the landowner did not, exercise a reasonable duty of care and maintaining the institutional property. That could happen today. I don't know exactly how that would play out in court, but the reason that the language on the Dam Safety Program's website provides all of that information is because the common law has established that there's liability associated with having dangerous infrastructure on your property. And so there is, it's reasonable to expect that you would be responsible for taking care of that.
You know, you have a duty to find out, you can't just say, I didn't know. You have a duty to find.
It depends on the context, but yes, you should understand what's on your property, generally speaking, yeah.
I could imagine coming up with someone inherited property, and they were at a distance, they'd never been there.
That's also a case in Vermont, where you have second homeowners who are not up here.
Okay.
There's also scenarios with orphan dams where the ownership's not known, and it requires a detailed legal analysis to figure that out, that isn't always available to be done because of the cost and challenges of doing it.
So even though it's on your property, someone might say, but it's not my dam, that assertion.
Occasionally, yes, there are instances where the dam itself has been transferred to another landowner. And so there's an underlying property owner, and then the dam might have been sold, but the chain of title is lost. That happens. There are some weird things that pop up when we're trying to identify dam owners.
The. If if questions of negligence come up. What are they measured against? Like, do they look at the state safety rules and safety rules and say, okay, that's gonna be our measuring stick, can you meet those? Or can they apply something else that's more demanding? But
This language in 213 would basically push them to be measuring against the dam safety standards, those rules. Without those design standards in place, a court is looking at the risk of harm associated with the activity, the landowner's actions and obligations. They look at a variety of factors in determining negligence currently. The design standards might create a more clear standard for evaluating against.
are the new rules, the rules that you're currently drafting or redrafting, are they changing the safety standard? So the rule of the measurement, the stick against which we're measuring may be changing with the new rules.
I would defer to Ben on this, but largely these new rules are adopting safety standards that we apply currently based on the Army Corps.
Or other federal agencies that have expertise in dam safety. We are using the most current version of standards that kind of exist, most cutting edge standards, though some cases, even if you go back a few years, they are different and new from what we've kind of applied in the past. Historically, we would apply, federal design guidance, and that was for a fairly broad term. It could be different federal agencies that provide such guidance, and we will allow people to work within those contexts of those different agencies in developing their projects.
Your rules incorporate by reference those federal standards, or you write them in?
The rules are in development.
The rules are in development, that they will be independent of those standards, that they will be standalones. We will have pretty clear standards on all the main elements of safety.
And if they become more stringent, when someone's operating a dam in good faith, does that mean that it's going to trigger a round of obligations on the part of every dam owner to say, okay, they're a little more strict now than they used to be, but now I need to find out whether I'm in compliance. So will they call upon the state to do an inspection, or will they do it privately, or how will they sort of keep up?
So, as we historically had a periodic inspection program for dams on our regulatory threshold. It's actually kind of been a voluntary commitment for dam owners. So there's some dams that have good records, some dams that have less good, some dams we're allowed to get on. That's kind of going away. All dams are going to be inspected in the future, whether it's done by us or if you're not willing to let us do it, we require you to hire an engineer to have that done. That's the kind of the first evaluation to assess the condition assessment, give the dam a condition rating. And then we now also have the authority to compel owners to start to make improvements, to come up to standard, which historically we could only make kind of broad recommendations that some people would follow, but if we didn't have any requirement or ability to make them follow them. So it's going to be quite a bit different in that context, we can,
And
it's how owners can move.
yeah, and if someone doesn't want you to come on their property, the state has the authority to compel admittance to a third party inspection.
Well, there might be an access order involved in that, but we haven't gone up against that problem yet. We also do allow the landowner to hire their own engineer to conduct the inspection and then provide the state with a copy of the inspection report. So
Then that's how we would handle that, would be required them to hire somebody to submit the report and certain deadlines. And under a certain standard.
So can we? Today, how do you, just trying to think about a little bit about what, absent 213, how you interpret liability at the moment. Can you just restate that, make sure I get how you're looking at it these days?
the state currently, so liability in the case of a claim for damages, so downstream property is damaged in some way. The determination of liability would ultimately be decided by, not by the agency. We have,
Because that's a private suit for damages.
correct, right, the agency's enforcement authority applies to compliance with what's currently in the statute, so that includes getting an order when you're modifying your dam. Complying, currently it does allow us to impose an inspection schedule, you need to get an inspection. So our enforcement authority applies to those regulatory, the regulatory scheme that DEC administers. We don't. We wouldn't be assessing liability directly on a dam owner. In any context.
Thank you, Mr. Chair. That's very helpful, thank you. In the scenario where there is clear, you have not ticketed someone, but you basically said, we've sent you letters. You're aware of the fact that you have been not properly maintaining your dam. I don't know if there are a lot of cases of that where you are sending those types of notices. That is something that someone would use in a court case, I assume, to make the case for damages, like. And that would still be true under this new this new laws, that could be used to say, yeah, you're not following state standards. We're sending you letters or notes saying, hey, we've seen some issues. It is my understanding. And then in the scenario where this is because there might be private ones, but the state also has them itself. Are there any examples where the state would be held, or a municipality is another shade of this, where they would be held liable for not meeting your own standards? Or so what happens in those scenarios?
The dam owner would be held liable.
And so that in many cases would be the state or a municipality or a utility company, is my understanding. Well, I'm very in favor of, if we are not maintaining a dam that we own as a state, we should be held liable for someone's house being flooded out that could have been avoided. I'm very in favor of that. However, could you describe why those scenarios are happening where we may not be in compliance? And is there a reason why it would be bad for the state to be held liable in those instances? Do you have a perspective on that?
I don't know if there are instances where the state itself is not in compliance. The dam safety program does an excellent job with its capacity of maintaining the dams that it owns. So I can't speak to that. The scheme of liability, if it were adopted in statute, would apply across the board. And the agency is not, we're not advocating for carve out.
Okay. Do we have dams out of compliance?
Yes,
How many dams do we have out?
so the high hazard dams, there's 44 high hazard dams in the state. 9 of those are rated in poor condition, so about 20%, 2 of those are state owned dams.
Okay.
4 are local government, 3 are private. I have the slides, I don't know if you want me to put
Yeah,
that,
we-
It's sort of the data I brought today, that was brought by.
Sure, I mean, I think, that I wanted, so There are two things I was hoping, not that we would settle everything today, but get started on, pieces. One is the liability and permitting piece, and start to chart a course towards clarifying the understanding and the language in the bill. And then the other thing is just sort of practically speaking, we're talking about trying to support the damage program better. And part of that is staffing, and then there's also a revolving loan fund to help facilitate repairs or removal, et cetera. And we need to start to develop a budget for that so that we're adequately funded to make progress in some sort of reasonable pace. So I think that's where my questions to you were heading, like the diagram of the Venn diagram, I took imagining of high risk for risk dams and then low or poor condition, that what would be in a first list and how much does it cost to address those?
Sure, yeah, so. We have a bunch of that data, we don't necessarily have extensive cost data.
Yeah.
Like I said, I have a kind of slide presentation with it's meant to address sort of the questions that you're after, so I'm happy to share that.
Yes, please, thank you for putting that together. And if you can, I don't know if you've already sent it to us, that way we can.
I apologize, I just finished it this morning, so.
On the website.
I appreciate that you're keeping up with us in real time.
Oh, look at.
This was put together this morning, so. There we go. So. This is the task that I was asked, or that what I was given was a prioritized list of dams at risk, condition in general, and costs expected. Like I said, we can offer pieces and parts of that, share everything that we have available to us, we don't have all of that. We have hazard potential classification and condition rating data for the majority and nearly all high significant hazard dams in the state. That's based on periodic and rapid inspections that we do, which is really the most basic level of assessment you can have for a dam. And keep in mind, hazard potential classification, which is the high, significant, low, is really the most basic assessment of risk the dam proposed that there is. And the next level is risk prioritization, which is what we've done on 18 state-owned dams, as well as 7 of the high hazard dams that we regulate that are poor condition. I shared that during a previous previous testimony, and the cost is expected. Like I said, we're fairly limited with cost data. We did do some cursory post flood 23 compliance cost data on dams that were damaged, so it is a kind of subset of our overall inventory, but that was looking like $60 million, and those are cursory costs. And I did sort of develop a very typical dam rehabilitation project costs slide just to kind of show you kind of what the steps are, kind of what ranges of costs are for at least rehabilitation projects. So this is sort of what you were asking, high hazard potential dams. By them being rated in poor conditions sort of signifies that they're in need of safety investment. 44 dams in our regulatory threshold that are high. 9 or 4, that's roughly 20%. You can see the breakdown there. State dams, there's 2, local government, municipal dams are 4, private dams, there's 3. Here's our list.
Oh, no. At least one in our district.
Well, you say there's more than one Silver Lake.
Yeah,
There's several, so like this is Silver Lake's and it's the state-owned dam in Barnard.
okay, yeah.
That sucks.
And then I only did this for significant high hazard dams. For significant hazard dams, I have 132 in the inventory. 59 are poor or unsatisfactory, which is roughly 45%. So, roughly 8 of those are state-owned dams, 7 poor, 1 unsatisfactory. Local government, 14 and 1, and private, 31 and 5. So we have a lot of work to do to have this a lot of resources are going to be needed to have this the overall condition and risk profile of the regulated dams in the state improve over time.
I mean, it's fair to just say there's a lot of deferred maintenance out there. Yeah.
Is there a plan for Silver Lake in Barnard?
Yeah, Silver Lake and Barnard, so that's a state-owned dam. So that one is actually right now we're in the process of a comprehensive assessment, which basically is an assessment to review available data on the dam, reflecting some physical data, doing engineering analyses with the goal of identifying, doing alternative analysis and identifying the best alternative to bring that dam into compliance, reduce its risk. So it's that one's kind of already on track.
To a layperson sitting there on the beach with lawns there, it looks pretty solid. What's the problem?
So that particular dam is a high hazard potential dam, meaning if it were to fail, it would result in probable loss of life downstream. dams have different types of standards that are required to meet based on their hazard potential classification, which includes the ability to safely pass a design storm or a flood, a certain flood size, and that dam is deficient in that area, it cannot safely pass the design flood. So yes, perhaps during a normal day, normal water level condition, the dam does meet standard, but during its designated flood load that's still safely pass, it cannot. So that's there lies.
So we have a schedule?
Compliance. Yeah, so we began the comprehensive assessment. I believe that's due to be completed around August of this year. That will come out with an alternatives analysis for which we'll share that with the local municipality as well as internal land management district stewardship teams. Hopefully identify an alternative that makes the most sense. That report will result in the alternatives with funding, with potential cost ranges. And then from there, we'll move forward to design and construction. So it's a couple year process to run,
Multi-year.
multi-year process to run the projects. Well, it depends on how quickly and readily the money is available, but typically your comprehensive assessment also depends, a lot of factors along the way. It depends on how much information is available for that dam, depends on how much you need to do to kind of fill data gaps to move forward. If there's a lot of available information, it can go faster. If there's not much, you got to do a lot of work, it can take longer, but comprehensive assessment could take a year, design could take a year, and then you're into construction. So 2 to 3 years would be about as fast as it really happened. In reality, sometimes funding's not there, it take necessarily longer. We have dams that took 10 years to go through that, so.
No, wait,
Thank you, Mr. Chair. It is very concerning to see a dam that is nearby or in our district, you may have picked up some of the nervousness and concern that the senators from Windsor County are expressing. And I'm gonna be very blunt, it is concerning to me that we do not have a proposal for some of your staff to be permanent. While also seeing what is very terrifying information about a high hazard dam. Do you feel that you could accomplish this work in a quicker timeline or to a better degree if you were better staffed, had more people? Because that makes me concerned that we are making a decision to allow these problems to continue. And I have not heard an advocacy for, because this is possible, this could be done quicker, this could be done more efficiently with more people and better funding. And it seems like we are allowing this situation to occur.
I guess there's kind of three parts to it. One part is dam safety regulation, which are dam safety rules we're trying to complete, are still under being completion, which is due for 2025. So our ability to compel owners historically and until then is pretty limited. So that's one part of it. The other part is
Don't love
staffing
that.
resource and available funding. So
Yeah.
all those three pieces sort of need to come together in harmony to make it as efficient a process as possible.
Do you feel that your agency is advocating for that path? I mean, that's a very difficult question for me to ask you, and you probably shouldn't answer it, and there seems to be a gentleman behind you raising his hand to potentially answer it, but I don't want to derail the conversation, but this makes me it is very concerning.
true, we have 218 and we've been talking about increased staff since December 5th, so I think we'll. There's a shared interest in increasing capacity. Commissioner Batchelder, I saw your hand move, you want to say, chip in here?
Only that I appreciate all the concerns, as do we as an agency and a department. The lens that we're here to look through today is a very specific one. The lens that you're asking about is one better answered by the secretary. We are circling up with her tomorrow to get our head around the broader scope of this bill, which the majority of it is in our bailiwick, in our ability to move forward, but we need our collective voice on here. We only have a small subset of folks here today. Fully respect S218 and its will. I'd also leave that to Deputy Secretary to comment on, but I would respectfully request, knowing my position here, that we stay on the topic that we're here to discuss today.
Okay,
So we will have the secretary in next week, and so.
I will ask the question again, because when you say high hazard, you mean loss of life.
The potential.
Yes.
And loss, high hazard, probable loss of life, so greater than 50% chance should the dam melt.
I don't know, that just seems a little. Okay, well, stay on topic.
So I mean, I wanna. I appreciate the concern, I think it's shared, but I wanna respect that we ask for information and
Yeah.
give Mr. Green a chance to present the data you put together.
Right, so for that, this is less than significant hazard dam, I not run this analysis on low hazard potential dam and minerals for kind of obvious reasons. This slide was just kind of describing emergency and non-emergency projects, and what that really means. An emergency project largely is one of critical time sensitivity. And it's usually a temporary measure that we're gonna take in an emergency situation to, basically to get control of that emergency. As opposed to a non-emergency project, when we're looking at a permanent risk reduction measure, we're looking to not do a Band-Aid, to buy time to actually, properly address the safety considerations and the risk issues. And I just have a couple of example projects there. That next level of, these slides are repeated from our previous testimony, but just that next level of risk assessment, it is a pretty sizable amount of work to do. We've done it on 2 different occasions. We have our A&R dam risk assessment where we assessed 18 state-owned dams, and this is sort of our prioritization list. And similarly, we used FEMA funding to do that for 7 high hazard potential dams that are regulated, not state-owned. So those are basically municipal, 1 privately owned dam, and we have a risk ranking for those. So we're starting to use this risk assessment as a tool to help kind of determine where risks are the highest and where we need to focus our limited resources. And then that's really the tools being used for there.
I would say I've lost track of PAR and PMN. Can you go over those again?
Yeah, so PAR is population at risk.
Okay.
So that's simply the number, that's not necessarily life loss, that is population at risk is the number of people that are basically within that flood inundation zone, whether it's 10 feet of flooding or an inch of flooding. If their home or property is in that zone, then they're included in the PAR, as opposed to life loss, which is usually a fairly small percentage of PAR. And then PMF stands for the probable maximum flood, which is essentially the worst combination of hydrologic events that could occur to cause a very large flood, something far greater than we saw in July.
Is it like a 500 year or?
Far more, yeah, I mean, recurrence intervals, it's actually not tied to a recurrence interval. It could exceed 1,000 years, to 10,000 years, to 100,000 years, sort of depends on a variety of factors.
Yep.
And then I think my last slide here is just a typical Vermont dam rehabilitation project. I'm just focusing on that as opposed to other alternatives for dealing with risk, which is removals also, but I just wanted to focus on a rehabilitation project just to kind of give an idea of the steps. So the large steps are, first is a comprehensive assessment. Then you have design permitting, selected alternative, and then you have construction, and these are just ranges of costs that I have in here and tasks that kind of go in each subset. And again, the more dam owners done over time to address issues and study issues, the more data they have, sort of the quicker and easier the process can go, because a lot of the data is known. Unfortunately, there's a lot of dams we just don't know a lot. You sort of start from ground zero, you have to collect a lot of data, so that's a factor. That's why these ranges are so large. But these are just that, they're approximate range, but a comprehensive assessment could run from 50 to 200,000. Design permitting of selected alternative again could run from 50 to 150,000, and then construction. And that's a very wide range of what construction means, because in some cases you can, a relatively minor fix might actually get you over the hump as opposed to basically a full rehabilitation. So, 250 to 750,000 are kind of some ranges that we see recently just for construction. So, that kind of gives you a sense for, kind of like an average project in Vermont that kind of goes from soup to nuts, kind of potential ranges of cost for bringing a dam, reducing the risk of that dam getting kind of into tolerable risk areas, and into compliance. And he's kind of give you an idea of the range of costs you could be.
And so those figures are for all, regardless of ownership.
No, this is just a generalized, this would apply to, majority of the dams on the list that you've seen.
Yeah.
So somewhere in these ranges, there's probably some that poke out higher, there's probably a few that are lower, but I think these are relatively decent range estimates of what you'd be looking at to bring up these dams, per dam.
So thank you. I think if I would follow up on, so thank you so much for pulling this together. And then ask if you could perhaps come with the secretary next week or something. we're gonna be talking about budget, you know, and so if you could start estimating, you know, maybe the high to low range for the high risk dams, addressing them, you know. How much money would it take so that we'll have a realistic idea of how much money would adequate revolving loan fund need in it to make support that work in a timely way. And my sense is it's gonna be a big number and that it's gonna be, we're gonna have to fund it for an extended period of time. Probably very little money comes back in on the revolving loan fund in the first. No, when a first payment's ever. Due. Okay, so thanks, I wanna remove the drama from this and just say we need the data, cost and timeline, so. Thank you very much for your help.
We do.